So again, when it comes to corporation by estoppel, is corporation by estoppel is no corporation at all because there is misrepresentation made by group of persons. Let all knows that they are that they constitute a corporation, and as an effect, the innocent third person or innocent third parties suffer loss. So in a suit against this corporation by estoppel, against this group of persons instituted by the innocent parties, the former cannot deny such misrepresentation. As in any other equitable concept, such group of persons will not be allowed to take advantage of such misrepresentation to benefit themselves at the expense of the innocent third parties. So again, it is obviously that these innocent third parties will file a suit, will file an action, either civil, will file an action in court against this group of person misrepresenting themselves that they are a corporation. These corporation by estoppel, this group of persons cannot deny misrepresentation. As in any other equitable concept, such group of persons will not be allowed to take advantage of such misrepresentation. That's the reason they cannot take advantage of the misrepresentation to benefit themselves at the expense of the innocent third parties. So, um, next question. We're in the nature. What is the nature of corporation by estoppel? The nature of corporation by estoppel founded on the principles of equity. Diba? This group of persons misrepresenting other people's or innocent third parties as a corporation cannot deny the misrepresentation they made, because on the ground of principle of equity, and they cannot benefit by misrepresentation at the expense of the innocent third person. Corporation by estoppel is founded on principles of equity and is designed to prevent injustice and unfairness where there is no third party involved, and the conflict arises only among those assuming the form of corporation who know that it has not been registered. There is no corporation by estoppel. Yes, there is no corporation by estoppel because corporation by estoppel is no corporation at all. It is founded on the principles of equity and to prevent injustice and unfairness where there is no third party involved, and the conflict arises only among those assuming the form of corporation. So can the doctrine of corporation by estoppel override jurisdictional requirements? Again, the question is, can the doctrine can the doctrine of corporation by estoppel override jurisdictional requirements? No. The answer is no. Jurisdiction is fixed by law. Jurisdiction is fixed by law, and it is not jurisdiction is fixed by law, conferred by law, and cannot be subject to mutual agreement of the parties. That is why the doctrine of corporation by estoppel cannot override the jurisdictional requirements, because jurisdiction is fixed and cannot be acquired through acquiescence or waive. Yes, acquiescence means mutual parties um, enlarged or diminished by any act or omission of the parties, neither can it be conferred by any acquiescence of the court. So again, the jurisdictional requirement cannot be override by doctrine of corporation by estoppel, because on the ground that jurisdiction is conferred by law, um, cannot be subject to acquiescence or waiver of parties, or even acquiescence of the court. It cannot be enlarged or diminished by any act or omission of the parties. Yes, jurisdictional is fixed. Um, the corporations, next kind of corporation is special corporations. Take the form of educational corporations. Special corporations take the form of, one is educational corporations, religious corporations, under religious corporations, corporation sole, and religious societies. So again, when it comes to social corporations, there can be two: educational corporations and religious corporations. Under religious corporations, there can be two also: corporation sole and religious societies. When it comes to educational corporations, these corporations are organized as non-stock and non-profit corporations. This is under Section 108 of Corporation Code. So, again, educational corporations are organized as non-stock and non-profit corporations. Non-stock and non-profit. A corporation sole, this is now with religious corporations. There are two kinds of religious corporations: corporation sole and religious societies. When it comes to corporation sole, it is organized by the head of a religious denomination, sect, or church for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church. That is under section 110. So again, when it comes with corporation sole, the aim for the formation of or institution or corporation sole is for trustee, being a trustee, di ba? It is being organized by the head of the church, the sect, or religious or any other religious denominations for the purpose of administering and managing, for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination. While when it comes to religious society, it is organized by any religious society. Now, religious society is um, organized by any religious society or order, or any diocese, synod, or district organization of any religious denomination, sect, or church, upon written consent and or by an affirmative vote of a meeting called for the purpose, at least two-thirds of its membership for the purpose of administering its temporalities or for the management of its affairs, properties, and estates. So corporation, the difference between corporation sole and the religious society, the in corporation sole, it is organized by the head of the religious denominations, sect, or church for the purpose of um, managing um, managing and administering a trustee. It's a corporation is a trustee. Um, it's a trustee of the affairs, property, and temporalities of any religious denomination. While when it comes to religious society, it's organized by any religious societies or order. Organized by any religious society order. Any diocese, synod, district organization of any religious denomination, sect, or church with a requirement. When it comes to corporation sole, there is no need for a requirement of a two-thirds of vote of membership, di ba? Held in a meeting called for that purpose. Only when it comes to corporation sole, only it is being organized by by the head of the religious denomination, church, or sect for the purpose of managing and administering as a trustee the affairs, property, and temporalities of any religious denominations. While when it comes to religious society, it is being organized by any religious society or order, district or church or sect, any diocese synod, um, provided upon written consent of all upon written consent by an affirmative. It should be with written consent, upon written consent with an affirmative vote of at least two-thirds, with affirmative vote of at least two-thirds of its membership in a meeting called for the purpose. And what's the aim of religious society? It's for the purpose of administering, managing its temporalities, its affairs, properties, and estate. So, let's talk about doctrine. Doctrine of piercing the corporate veil or piercing the corporate entity. What is this doctrine? The doctrine that a corporation is a legal entity. Distinct. A corporation, its personality, its being legal entity is distinct, separate or different from the persons composing it shall be disregarded. In this doctrine, this is very famous doctrine, doctrine of piercing the corporate entity, the corporate veil, di ba? The doctrine that a corporation, yeah, di ba? As we all know, the corporation has a legal entity distinct and separate from those composing the corporation, from those individual being. It shall be disregarded. The legal entity distinction, the legal entity distinction between a corporation and those people or persons leading the administering or managing the corporation shall be disregarded. So it means to say, it pierces the corporate entity. It it separates, diba? When the veil of corporate fiction is used as a shield to perpetuate fraud, to defeat public convenience, justify wrong, or defend a crime. Thus, piercing of piercing the corporate veil refers to a situation in which court put aside the limited liability and hold a corporation's shareholders or directors personally liable for the corporation's actions or debts. It means to say, um, it makes these directors, presidents liable for corporation's actions or for corporation's debts. Because when when does this happen? When will this doctrine piercing the corporate entity will happen? When this doctrine may apply, rather, when the veil of corporate fiction is used. So when these directors, persons, or officers in the corporation use the name of the corporation to shield the to perpetuate fraud, to defeat public convenience, to justify wrong, or defend a crime, then therefore the court will pierce the veil and will separate um, these persons, or will make these persons, directors, presidents, or any officers liable for corporations' actions or debts. We will just talk about more about this doctrine of piercing the corporate entity along the way. Next, what's the advantages of corporate form over partnership and sole proprietorship? So this time we are already talking about corporation over partnership and sole proprietorship. So how is that? the question is, give at least three advantages which a corporate form of business organization has over the sole proprietorship or partnership. So what are those at least three advantages of being a corporate in form over being a corporate over sole proprietorship and partnership? So first, these are the three advantages which a corporate form of business organization has over the sole proprietorship or partnership. First is the limited liability. Second is the ability to generate capital. And the third is the capacity to attract good executives. So now let's go with what's limited liability. When it comes to limited liability, in sole proprietorship, there is no limit. When it comes to limited liability, when in sole proprietorship, there is no limit. Except properties exempt from execution under the rules of court. Diba? There is no limit when it comes to sole proprietorship. No limit for sole proprietorship when it comes to limited liability. No limit exempt exempt properties exempt from execution under the rules of court, while in partnership, each partner is liable to the debts of the partnership and those of the other partners. Yes, as a rule in our agency partnership and trust, partnership, all those partners are solidarily liable to the partnership's debts. Diba? The action of the partnership, um, the action of partnership is the action of partnership is also the action of the partners. Next, each partner is liable when it comes to partnership. Each partner is liable for the debts. Each partner is liable for the debts of the partnership and those of other partners. Each of the general partners of a partnership is mutually constituted as agents of the partnership and of each other. That is why the doctrine of um, delictus personarum applies to the partners in the choice of those with whom they are to associate themselves in business. So, when it comes to general partnerships or the general partners of a partnership is mutually constituted as agents of the partnership. So again, these partners are agents of their partnership. But partners are covered under their partnership. So each partner in this partnership are agent of this partnership. So the action of the partnership is the action of each partner. So therefore, the each partner in this partnership is liable to the liability of the partnership. So again, when it comes to liability of partnership, each partner is liable. So each of the general partners of a partnership is mutually constituted as agents. Yeah. Diba? Each of the general partners of a partnership is mutually constituted as agents of the partnership and of each other. That is why the doctrine of delictus personam, the doctrine of delictus personam applies to the partners in the choice of those with whom they are to associate themselves in the business. So we will just talk about this. What do we mean by delictus personam, di ba? It is applies, this doctrine again applies to the partners. Applies to the partners in the choice of those with whom they are to associate themselves in business. In corporate form, so as a review again, when it comes to sole proprietorship, there is no limit There is no limited liability. There is no liability except when exempted. Except those properties exempt by the rules of court. Exempt from execution. In partnership, each partners are liable to the partnership's actions or debts. Each partner is liable for the debts of the partnership and of those of the partners. Diba? Each of the general partners of a partnership is mutually constituted as agents of partnership. So in corporate form, a stockholder is liable for the obligations of the corporation. Again, a stockholder is liable for the obligations of the corporation only to the extent of the amount of the subscription, of this subscription. So there is limited liability when it comes to corporate form, wherein the stockholder shall only be liable to the extent of his subscription amount. If he has fully paid for his subscription, a stockholder is no longer liable for the debts of the corporation. This is now a removing liability from a stockholder. If he has, or if the stockholder, diba? The stockholder shall only be liable, the stockholder shall only be liable for obligations of the corporation only to the extent of the amount of his subscription. And the liability of a stockholder shall only be to the extent of his amount of subscription. But if he has fully paid, if that stockholder fully paid his subscription, his or her subscription, then that stockholder is no longer liable for the debts of the corporation. Again, stockholder shall only be liable to the extent of his or her amount of subscription if that stockholder fully paid his subscription, he or she is no longer liable to the debt of the corporation. That's the limited liability. That's the advantage of corporate form over sole proprietorship and um, partnership. The second one, it's the ability to generate capital. In both sole proprietorship and partnership, the raising of capital is limited to the individual resources, di ba? Oh, in both sole proprietorship and partnership, the raising of capital is limited to the individual resources of the sole proprietor or the partners themselves. So again, in both sole proprietorship and partnership, the raising of capital is limited to the individual resources of the sole proprietor or the partners themselves. So it shall only be the capital shall only be to the extent based only to their individual resources. When it comes to capital, capital is equals to individual resources. That is for sole proprietorship and partnership. But when it comes to in case of a corporation, the generation of capital may be had through the issuance of shares of stocks, diba? That's the generation of capital may be had through the issuance of shares of stocks to be sold to the public. This is in addition to the capital that may be raised from the personal resources of the stockholders by way of increase in the authorized capital stock to be subscribed and paid by the stockholders of record. Again, when it comes to a corporation, the generation of capital may be had through the issuance of shares of stocks. May be had only through the issuance of shares of stocks to be sold to the public. So the more shares that they can sell, the more buyers to the having shares, the bigger the capital. The generation of capital may be through the issuance of shares of stocks to be sold to the public. This is in addition to the capital that may be raised from the personal resources of the stockholders by way of increase in authorized capital stock to be subscribed and paid by the stockholders of record. So again, these stocks are being bought by stockholders as so it is in the form of shares of stocks. The more shares that they can sell, the more the corporation can sell the shares, their stock, the bigger the capital that they can generate. That is when it comes to ability to generate capital. When it comes to capacity to attract good executives, due to its financial muscle, a corporation is in a better position to attract able and competent executives than a sole proprietorship or a partnership. Because sole proprietorship only, it may be only one person, and partnership may be two or more persons, diba? So when it comes to corporation, it caters all. It caters all. So therefore, uh, it has the capacity to attract good executives. Kinds of shares of